this is Stephanie Gordon at Gordon Property Management. Today we're going to talk about how to deal with tenant security deposit disputes in San Francisco under rent control laws. And actually the rent control laws really don't have anything to do with a dispute over a tenant's security deposit. That's handled by our regular laws. So if you get into a dispute with a tenant over a security deposit, you're not going before the rent board. That tenant's going to take you to small claims court. So those kind of disputes are settled at small claims court, and it's like anywhere else in the country. How to deal with disputes? The best way is to not get into one, and you can do that by documenting the condition of your property when a tenant moves in and documenting the condition when they move out. With digital cameras, there's no reason to not take pictures. Take lots of pictures, particularly of the things that are in really good shape, like if you've just refinished your floors, take a picture of it. If you've got something that's cracked or broken or, not 100% the way it should be, take a picture of that so that you'll forget what the condition was when they moved in. So document when they move in. Once you get a 30-day notice from them that they're moving out, you by law need to give them the opportunity for what's called a pre-move out inspection. And if you don't do that and you charge them for something, you could lose right there because you didn't do that inspection. So you should send the tenant a notice that you're going to do the pre-move out inspection. It needs to be within 2 weeks of when they actually vacate. And that's an opportunity for you to go in and tell the tenant what they need to do in order to get their deposit back. Obviously it's not going to cover cleaning because they haven't cleaned yet, and it's not going to cover things that you can't see. But if you go in and they've knocked the towel bars off the wall in the bathroom, or there's a plant on the wood floor and you can see that the floors are stained, you need to, at that point in time, in writing, let them know that those conditions are unacceptable. Then once they move out, you have 21 days to return their security deposit to them and account for any charges. And you need to actually have those charges. You can't just make it up, and you can't just say, well, they damaged the floor, so if I were to refinish it, this is what it would cost. You actually have to incur those charges. And if you are doing the work yourself, it has to be a reasonable hourly charge. You need to give them copies of all of the invoices for that work along with the security deposit. If you haven't completed all that work, you need to give them an estimate of the charge. My advice is a security deposit is not a profit center. You need to be fair. You need to realize that if you've had a tenant in there for 3 or 4 years, you're going to need to paint. That's normal wear and tear. If they've put pictures up, that's normal wear and tear. If the floors are a little bit scuffed here and there, that's normal wear and tear. You cannot expect the unit to be in the same condition it was when they moved in. I think that's where landlords really get taken to task by tenants, is when they are overcharging. You need to be fair. How would you like to be treated, or how were you treated back when you were a renter, or your son or your daughter? How would you want them to be treated by a landlord? And I really think that you do need to be fair, and security deposits are not meant to be a profit center. So otherwise you'll end up in court, and it'll be to the judge. And that takes a good half a day to go to small claims court. If you haven't done it before, it's really not a very fun process. Judges do not like landlords who are not fair with a security deposit. So that's my best advice about how to deal with tenants and their security deposits. I'm Stephanie Gordon at Gordon Property Management. Thank you.